Okay, this is the State of Iowa versus Todd Michael Mullis, Delaware County case FECR 012941. We, the jury, find the defendant, Todd Michael Mullis, guilty of the crime of murder in the first degree, signed by the jury foreperson.
Todd Mullis was convicted of the first-degree murder of his wife, Amy, as you heard there. Now, Mullis was sentenced to life in prison without the possibility of parole. Now, at his sentencing, Mullis continued to proclaim his innocence.
Is there anything you would like to say today?
I did not do this. This is supposed to be America where you have a fair chance of proving your innocence. We shouldn't have to prove your innocence. Instead of the other way around, I thought it was guilty until, or not, innocent until proven guilty. I feel this is the other way around. And I was a faithful and loving husband, and I never did this.
Well, now that September 2019 conviction is under the microscope, Mullis has filed an appeal of his conviction with the Iowa Supreme Court, claiming there's not enough evidence to support his conviction. Let's take a look at a hearing that happened yesterday in Iowa.
We believe that this was an accident. We don't believe that this was a murder.
What is the direct evidence, or even circumstantial evidence, that anyone besides Mr. Mullis committed this crime?
And that's assuming that it was, Your Honor, that it was a crime and not an accident.
The client testified under oath that it was not an accident.
You know, we don't have any evidence that anybody else was on the property that day. I have not heard anything come forward. You know, did that if this was a crime, did that happen? It certainly could have happened, and they didn't see anybody. They were in the hog barn working that day.
This is not a close case. The evidence of Todd Mullis' guilt is simply overwhelming. Only Todd Mullis and his son Tristan knew that Amy Mullis was going to that red shed. Only Todd asked her to go there. Only Todd placed the murder weapon in that shed within a month of that time. Only Todd had multiple strong motives to kill Amy. And only Todd, while purportedly giving her CPR to save her life, whispered, "cheating whore," and "go to hell, cheating whore."
We will issue a written decision in due course. Thank you, counsel, for your arguments today.
All right, joining me now, family law attorney and law professor Randy Kessler. Randy, you know, you deal in family court, so you see a lot of this kind of stuff where folks are cheating on each other, and at times it can raise to the level of what we saw here. Now, what they're claiming, there's three basic claims they're making: prosecutorial misconduct, and that dates back to the claims by the prosecutor of what was heard on that phone call. Mullis was deprived of counsel because they didn't concede that it was, they conceded, that someone else must have did it, not that it might have been an accident, and that the verdict was contrary to the evidence. So first and foremost, let me ask you about appeal on that grounds, how difficult it is when you have a case like this, which I think you were on a few times during this trial. I know I watched the entire trial. Okay. I agree with the prosecutor. There was plenty of evidence to convict Todd Mullis.
I think you're right, Michael. There was plenty of evidence to convict, and the people that have to weigh that evidence are the jurors, not the Supreme Court, not the appellate courts. You know, a lot of people have this misconception that, well, the facts didn't prove that I was guilty. I can argue those facts to a higher court. I can go to the appeals court and say, those facts shouldn't convince you that I did it. That's not the issue on appeal, right? Appeals are a matter of law. Did some law get violated? Was he deprived the right to counsel? Was there something that was admitted into evidence that should have been admitted into evidence? You know, we can agree or disagree about whether he's guilty, whether it was a close call. Boy, it's terrifying when you hear someone at sentencing say, I'm still innocent, and you have that tinge of, maybe he is innocent, maybe we're putting away someone who's guilty, and we all don't want that, right? We'd rather have 10 guilty people on the street than one innocent person in jail. But the appeals court is not the time to second guess the jury. The appeals court is for legal error. It doesn't seem like there's legal error here.
Yeah, and the appeals court has to look at all the evidence when you make this suggestion that there wasn't enough evidence. They look at all the evidence, making all the inferences in favor of the state. And clearly, again, there was a lot of evidence here, so they're certainly not going to win on that particular point. Now, let's talk quickly about the right to effective counsel. Talk to me a little bit about that claim. They're really quibbling with the tactics used. They claim that he didn't do it, but that somebody else might have done it, rather than saying, as they're saying now in the appeal, that it looks like it could have been an accident. And they're saying they didn't take that tact, so that amounts to ineffective assistance. Your thoughts on that?
Yeah, ineffective assistance, the legal equivalent of the football term, right? Hail Mary. When all else fails, you say the lawyers didn't do a good job. He got found guilty. So maybe that's just proof that the lawyer didn't do a good job. But you're dealt the facts, and you play the facts, or you play the hand that you're dealt. I don't think this was ineffective assistance of counsel. We've seen that in other cases. This was a well-tried case. Maybe the lawyer made some judgment errors. Maybe the lawyer should have put him up earlier, or should have had another witness, or should have done further investigation. There are a lot of what ifs. That doesn't amount to ineffective assistance of counsel. Ineffective assistance of counsel would be someone who was a contract lawyer and never stepped foot in a courtroom, all of a sudden taking on a murder trial in the defense of a murder defendant. That might have been ineffective assistance of counsel. This one does not qualify, in my opinion.
Yeah, and the final thing is, this idea that there was suggestion by the prosecutor of what's on that tape. Certainly that was an important piece of evidence, but there was tons of other evidence. And she was very adamant. She pounded on that point. It was something that really, the passion that she showed about what was on that tape, the fact that he called her what he did. I don't even want to repeat the words. But at the end of the day, she can say those things, correct? She can be passionate about what she thinks she hears, because that tape goes with the jury. They can listen to it, and they make the ultimate decision.
Right, and it's very risky for a prosecutor, because if the majority of the jurors think that's not there, the prosecution is leaping to this conclusion to try to put away an innocent man. That could backfire on her. So you got to feel pretty confident that you're right when you make those kind of statements, those kind of pronouncements, and you pound on the table like that. Apparently it worked.
Yeah, it worked. And I'll tell you, I still don't know exactly what he said, but I can tell you this. They